Very good afternoon to everybody that's joining us on this Wednesday afternoon. Wherever you're from, do comment in the comment box and tell us where you're from. Are you joining us from Johannesburg, Durban, Cape Town, Port Elizabeth? We'd love to know where you're from. Joining us this afternoon, and a great honor is from VZLR Attorneys. I posted the link in the comments already. It's Michelle van der Merwe. Michelle, a very welcome to you.
Hi, Neil. How are you?
You can't complain. So you're surviving through this lockdown period?
We have been working very well remotely. We've been doing all of the work that should be done. And I must say, change is a good thing for all of us. Getting out of our comfort zone, getting new challenges. It was amazing. So how was lockdown treating you?
Look, I've adapted, and I think I need a haircut. My hair is extremely long. One of your colleagues know how long my hair can go. At some point when I was studying law with him, my hair was this long to my shoulders. So I think most people don't want to see that again. But we adapt and we change, and it's about keeping positive at the end. I like your dress code, Michelle. You don't look like an attorney at all. It looks more like you're going into fashion modeling or something.
Thank you for the compliment. Well, working from home, usually when we're at work, it's any color as long as it's black. Now that we're working remotely, we choose color. So it's a good change as well.
Awesome. Today we're going to be talking to Michelle with regards to family law during COVID-19. You'll be able to ask any questions with regards to anything family related during the COVID-19, anything family related to Michelle, and she's going to try and answer that. Obviously, if you've got any other legal questions, you can pose it through, and we'll see if Michelle's happy to answer it, or if one of her colleagues would like to get back to you. VZLR Attorneys is one of the biggest law firms in Pretoria. They don't just have offices there, but they have offices outside Pretoria as well. I'm just going to go through some of the areas they practice, and it's on the link that I've sent through in the comments already. I'll display it just for those that want to see it. I'm just going to take that away. And some of the areas of practice is conveyancing and real estate, corporate and commercial law, banking and financial law, personal injury, third-party claims, medical law, general litigation, insurance law, family law, labor law, cost consulting, estates and wills. It's a lot of areas, and you're a massive law firm, Michelle.
Yeah.
How many people work there?
We're about 180 personnel, so it is one of the big, if not the biggest law firm in Pretoria. And the idea of it is to be a one-stop shop. So we have most of our clients that we can service from commercial to the family law. So we want to be the person that when you call, we can help you with anything that you need.
Well, it definitely seems like it. And I know from Oracle Media points as well, our side, we've worked with VZLR Attorneys before, and we've had great service. And that's what you ultimately want when you're looking for the legal side. You want to know that you've got an expertise and so forth. So obviously today we're talking COVID-19, family law, and you can post your questions in the comment box. Before we start with Michelle, I obviously have to remind everybody on who our speakers are for June. Starting June, we'll only be having these sessions every single Wednesday at 3 o'clock. We will no longer have it on a Monday or on a Friday, so every Wednesday at 3 o'clock. Starting off in June, we'll have Ida Fenter on the 3rd of June. The 10th of June, we'll have Shelley Mentor. She's a business coach. Following that on the 17th, we will have Kevin McLagan on. He is a social media influencer and also a digital manager at one of the massive liquor companies in South Africa. And also ending of June, we'll have Beulah on, which is she's a doctor, and she's going to be talking how the mindset and taking educational online has changed specifically. And that's our speakers for June. That's all on our Facebook page, and you can go on there to have a look at that specifically. So just to go on for people joining us, Lynn joining us from PE, Baldu is joining us from Pretoria, Christine saying hello from Port Elizabeth, Nathan from Johannesburg, Marcel is joining us also from Port Elizabeth. Hello Marcel. Marencha, my mother, is joining us from Port Elizabeth. Hey mom. Emil is also joining us from Pretoria. Ilse from also from Pretoria. That's also one of my mothers. Joanne joining us from Pretoria. Panyata joining us and saying hello. Everybody, she's from Remax, Port Elizabeth. Mark from the N1. Mark, I hope you're not driving at the moment. And Belinda also joining us. Hey, Belinda. So quite a few people joining us at the moment. As we got on this morning, how it works, this afternoon, how it works. If there's any questions for Michelle, you can just comment in the comment box, and I'll be going through that specifically. So Michelle, obviously we're looking family law, and there's been so many people asking questions around that, how it's affected during COVID-19. So since the start of the lockdown, which is obviously, for those that can still remember, the 27th of March this year, several changes have occurred with regards to the movement of children between the divorced and separated parents specifically. Can you take us through that?
So, Neil, it's important to start to give a brief history. Once we've started with the lockdown, the parents being divorced, separated, and the co-holders of parental rights and responsibilities were not prohibited to move any of their children between their households. Even if they had a court order, this was not allowed. But then with the regulations that have been amended on the 7th of April, they relaxed these regulations to state, well, if you are in possession of either a court order or a parenting plan, then only will you be allowed to move these children between the households. Now, the problem with that was immediately, what about the children whose parents weren't married, or the children whose parents started litigation, but there's no court order at that stage? So then it's discrimination against those children. So during that time, we were approached by so many people requiring an order by agreement to ask the court, well, please then just grant me an order so that I can affect this movement in this time. The courts, however, said, well, this is not an extreme circumstance at this stage, so we are not going to intervene. That in itself made major problems during that stage. But then, just about 10 days afterwards, the regulations were amended again, and that was on the 17th of April. So with that regulations, it then broadened it to say, well, if you have a court order or a parenting plan that had been registered with the family advocate and also now a birth certificate, you are allowed to then move the children between the households, which are between the co-holders of the parental rights and responsibilities. So that helped a lot. But in the current circumstance, which was again amended on the 29th of April, and this is the current regulation that we are working with, it has been amended to say, well, you either now have to have a court order, you either have to have a parenting plan registered with the family advocate, or you need a permit. So with that permit, you need to approach a magistrate. So with all of these amendments, it creates frustration with the parents. It creates, it's a not secure safety place for the children, because with each and every amendment, there's a different regulation that you need to follow. So with that, to approach a magistrate, you would have to fill out a form. So they called it a Form 3, and it was annexed to the regulation. And in that, you would state what your details are, what the kids' details are, as well as why the reasons are you want to move those children between their households. So with that question came the most popular question. So if I want to move my children between provinces, what do I then need? Do I need a permit? Is my court order enough? Is my parenting plan enough? And that is all of these differences and the uncertainty that formed with all of the people. But just to clarify that, at this stage, if you have to travel with your kids cross-border, you need a permit from a magistrate. You would have to take your parenting plan, you would have to take all your court order, and then approach the magistrate and ask that he issue a permit to allow you to travel cross-border with your kids during the stage.
So that's our current regulations now. I need to go to a magistrate, obviously get a permission.
Yes.
Is that obviously through you, Michelle? So they'll approach you as the attorney and you will represent them at magistrate court?
It's not necessary to approach an attorney. You are welcome to email me and I will send you the form. It was attached to the regulation, so they call it a Form 3. So in that, it sets out all of the details and all of the documentation that you need to take the magistrate. So uh, anybody can approach the magistrates themselves in their personal capacity.
Awesome. So it is easy to do in that sense. Niku's asking me, hey Neil, which law firm is Michelle from? Obviously, Niku, she's from VZLR Attorneys. If you want details there, just scroll up to the first comment and you'll see the link to their website in terms of it. We're talking to Michelle with regards to family law during COVID-19, and you're more than welcome to ask any questions with regards to law in the comment box, and Michelle will be able to answer it when we get to close to the end of today's session. So we're also now looking at moving to level 3 on Sunday, which again is probably going to cause more confusion for people. What does this entail and with regards to movement and all of that? So can you take us through to what now is happening, obviously, when we move to level 3 on the 1st of June?
So, Neil, I have not seen the regulations published. I don't know if they are published, and as far as I'm concerned, they're not published as yet. There has been a few documents that have been circulated, but at this stage, I can't with surety say what the regulations would entail. It seems like it would be relaxed a bit. It seems like the permits would only be if you are moving from different provinces or different levels, but at this stage, we don't know as it hasn't been published.
Then also, I'm sure a lot of people are asking, so from Sunday, you're obviously allowed now to go to church services within the parameters of law. Say, for example, I'm now divorced and I've asked my wife, please do not take our kids to church this Sunday, or while COVID-19 is quite hectic in the country. Even if they've gone to church before COVID-19, I'm asking, please don't go at this stage and attend church services. What is my rights as either parent, mum or dad with regards to this specifically?
So usually when both parents are, in accordance to the Children's Act, are the co-holders of parental rights and responsibilities. And with that, you have the right to discuss major issues like this. And if you cannot reach an agreement, then it is usually referred to a mediator to try and solve these disputes between the parties so that you don't immediately run to court and lodge an application. These circumstances are so special, and it's new things, it's new parameters that we don't know. But things like these and questions like these will, at the end of the day, I think, end up in court, because you will have two parties that both act in the best interest of their child, but with different approaches. So it's a gray area to say, well, who's right and who's wrong. So it has to depend on each matter on its own.
Okay. So obviously, the best way will be if parties do not agree to get a mediator involved, with regards to things like this. And just say worst case scenario, I've asked the co-parent not to do it, and that co-parent ignores my request completely and just takes my child to the church on the Sunday. Is that again to proceed to to mediation?
Well, let's ask it this way. So many of the parents during this lockdown time were essential workers, and they were exposed every day, and still they return to see their children every day. But with the necessary precautions and the necessity and the safety precautions that you take, we need to then ask ourselves, when and where do we draw the line? So if you want to expose, and I'm saying expose for the lack of a better word, but if you take all the necessary precautions and you ensure safety and you ensure sanitizing and the hand wash and the masks, then at the end of the day, we will have to then approach that matter by the circumstance and see why the parent does not want to, why the parent does want to. And as I say, it's gray areas, and we'll have to take it one case at a time.
Definitely. Thanks for that, Michelle. Lauren also joining us, saying good day, Neil and Michelle. For those of you joining us at the moment, we're talking to Michelle van der Merwe. She's from VZLR Attorneys. I've posted the link as the first comment. You can see the website there, VZLR and we're talking family law during COVID-19, how it's affecting parents and obviously kids, if you're separated or divorced. What's your rights specifically, and how is it also changing going forward with regards to things? So you're more than welcome to ask any questions with regards to anything law related in this session, but also specifically during family law and COVID-19 specifically. Now, also one of the most frequent and urging questions you most certainly get is probably that I've waited so long to finalize my divorce, and now with the lockdown, when will I be heard specifically? Can I get a divorce during lockdown? What is the way forward?
So what happened during the month of April, all of the matters that were set down had been postponed. The court actually started functioning on the 4th of May and during that week, and it was only limited matters that could be heard. I was lucky enough to have a few unopposed matters being set down during that week. Now that came with its own challenge because each of the judges had their own directive and their own manner in which they wanted to deal with the matters set down before them. So what was interesting during this matters is usually in unopposed matters, you take your client to court, they need to testify, and they need to satisfy the court that all of the arrangements and agreements they've made in relation to their kids is in the best interest of those children. Now, with these unopposed matters that were set down from the 4th of May, all of these matters were heard by way of affidavit. Now, in the normal circumstance, no unopposed matter was heard by way of affidavit. So now we approach a different manner, a different way of handling things. And what the further thing was, and what happened in one of my matters was that the family advocate did not endorse my settlement agreement between the parties. So what that means is they were of meaning that that settlement agreement was not in the best interest of that minor child. However, this was an arrangement that was being kept up between the parties for a while now. So with that, the judge then said, I'm going to allocate you a certain date and a time, and I want you to address me on this aspect. So this was new for all of us. So my counsel, myself, and client sat around with each of our laptops, and we were waiting to enter into a virtual courtroom. So when the judge was ready for us, she would let us literally in, and she addressed the counsel, spoke to her, asked her questions, and then wanted to speak to the client herself. She then, as the judge, sworn in the client herself, and then had a conversation with the client to ask her, why are these the agreements that you've reached? Why is this in the best interest of the minor child? And with that, she was satisfied. So this meant that we got our degree of divorce, we got our incorporating the settlement agreement, and I must say, Neil, I think this is the way forward. I'm of the opinion that all of the unopposed divorces are going to be heard in such a manner. Unopposed motions for that matter as well. The time and the date is going to be allocated. We're going to log into this virtual court, and these matters are going to be dealt with in this manner.
So more just virtual courtrooms, I would guess it was probably over Zoom, and then doing it like that going forward. Now, another question that I have, Michelle, for example, say one of the parents was paying maintenance during this period, and they were not paid a salary at the end of April due to the company not having any money. Or even there was a reduction in salary specifically, which has now affected the means of paying maintenance. What would you suggest here?
Well, that is a question that was in most of the matters because that's a reality. So hopefully in these circumstances, the parties can reach an agreement to say, well, my salary has been reduced to this amount and I cannot afford this, or I don't have any salary, so please help me and I'll pay with, let's contact all of the suppliers and ask for maybe a reduction or maybe this or that. But at the end of the day, if you cannot pay, there is still a court order that stands and that you are in contempt of that order. So if this is still going on, you would have to approach a court and ask for a reduction based on these circumstances. Otherwise, you are in contempt of your court and a warrant could be issued.
Is there a timeline for that specifically? Say a lot of companies are still waiting for TIRs. So say I'm the dad now and I haven't been paid and I'm waiting for TIRs to still pay out to me by the employer. Should I do that in the interim? should I be in the discussion with the co-parent specifically, or should I wait to see when TIPS will pay out to me? Obviously, a person doesn't want to get into trouble.
No.
So is it better to speak beforehand?
So it's of utmost importance that communication is obviously the way.
Michelle, you there?
Can you hear me? Neil? Can you hear me?
I'm sorry, Michelle, you just broke up there for a second. Are you there?
Okay.
Can
you hear me? Neil, I'm seeing you. I'm hearing you.
Michelle?
No? Neil?
Can you hear me, Michelle?
I can hear you. Can you hear me?
There we go.
Okay. We back?
That's perfect. It's probably just a glitch in the internet.
A hiccup.
Yeah, go for it.
Okay, so in this circumstances, communication would obviously be the solution. If you and your partner are on good communication grounds, then obviously, hopefully, you can come to some or other agreement. But if not, then you would have to approach your attorney. And I mean, in these circumstances, it's absolutely reasonable to understand that there has to be a reduction, that you would not be able to fulfill your court order. And the fact that you have contacted your spouse or your ex-spouse or your attorney shows your bona fide intention. It's not like you are just shying away from your court order or just stating, well, I'm being malicious and I'm not paying. So the fact that you show your bona fide intentions goes a long way.
So it's better to have the communication before. And I see a lot of people saying the internet fault is on my side. Sorry for that. Thanks. Janine's joining us on midstream. Joanne also saying we can hear you, Michelle. So and then also saying I hear Michelle. So it's obviously on my side. Apologies for that, Michelle. So communication is key, is what you're saying with regards to that. We're going to get to our last few questions. For anybody that's got questions for Michelle from BZL or attorneys, please do post your questions in the comment box, and then I'll ask those questions next. So just in the comments and just in the comment box, any question that you may have for Michelle, and I'll bring it over to her. Before I get to the last questions, Michelle, obviously, these are interesting times and you have to take it step by step. Now, if, for example, if I custody and because I was fully employed and so forth, and I've lost my job now through this, does that also affect my custody at all? Because this may be a worry one mom or dad could have at this time.
Look, I mean, the financial security that you can give your children does not make you a bad or a better person. You could have all the money in the world, but it doesn't make you a good parent. So no, finances does not establish the primary caregiver. It does not establish, and that's nothing to be worried about. If the finances is something that, if finances is the only reason why you think or why you are being threatened that your children might be taken away, then there's no basis for that. So, I mean, and this, once again, this is where the communication comes between the parties to say, well, these are the circumstances. How can we help one another? Because at the end of the day, because the parents don't agree anymore and because the parents aren't married anymore, doesn't mean that you have to let your children suffer through that. So always have the best interest of the minor children, you know, it's of paramount importance. So no, finances can't influence the primary caregiver or the primary residence of their children.
Awesome. Thanks, Michelle. So just a question outside of COVID-19 with regards to divorces. If two people decide to get divorced, is it best to just go to an attorney directly together and obviously media and say we want to get divorced instead of going to two separate attorneys? It's just a question I've also had in the past. You know, what is the best process with regards to it? Obviously, it's not on good terms, but what would you suggest there?
Yes. Well, it depends on the circumstances. So if parties come to me and they say, listen, we've agreed on most of the terms, I'll sit with both of them and we'll go through all of it. there's an obligation upon myself as a legal representative and as a person of court. So to then explain to both of them to say, well, these are your rights. This is what you're entitled to. Maintenance regards to, and these are open conversations. And what happens most of the time, especially when you start touching maintenance payable for lifelong or rehabilitation, that's usually when the hiccup comes in. But I can assist parties and help them to mediate as far. And then I draft a settlement agreement, which both of them signs, and we go to court. So yes, it is a very good solution if the parties can agree. I can also help to mediate up until a certain point, and then I say, well, I'm sorry, guys, we're not moving forward. I can't be, I'm not objective anymore. So I would then refer both of them to separate legal attorneys, and then they have to fight it further.
And that obviously becomes quite expensive.
Yes, it does.
For those who'd like to contact Michelle, and I'm posting the email address. I did joke earlier with her that I'll post the WhatsApp details, but I'm not going to do that, Michelle.
Let's start with the email address. Would be awesome. Thanks.
I'm just going to post it again. It's posted twice.
Yeah.
So to contact Michelle, you can obviously contact Michelle, and I'm going to show the email address now as soon as it comes up. While it comes up and we wait for it to show, don't forget next week, Wednesday, we've got Ida Fenter that's going to be talking on a Q&A specifically about her life and the business she's in as well. So there's Michelle's email address. It's michelle@dzlrattorneys.co.za. And you can also go to their website, which is quite easy, www.dzlrattorneys.co.za. Any questions or anything for Michelle, you can direct it straight through to her email address. For those that may have been shy, we know this is a topic that a lot of people don't always want to talk in the public specifically. So I do understand if there's some questions people don't feel like they can ask that in front of everybody. So Michelle will be open. You can email her on that email address, and she'll be able to help you with that. Michelle, any last thoughts or something you'd like to share with regards to family law with us?
I'd just like to make a suggestion, Neil. As if we receive the new regulations, you guys are welcome to email me. I'll put the names on an email list, and as soon as I've received confirmation or read through the new regulations, I can email you all of the details, what's going to be expected of you, what documentation you need, what don't you need, and how it's been changed. So that obviously makes the whole process easier. It gives you the safety and security when driving around. And I think it's just for that safety in the future, just to know and to be informed.
Awesome. Thanks so much for that, Michelle. And thanks for joining us today. I think a lot of people have gotten some idea, during COVID-19, how it will operate. And obviously, when we go back, if we go back to level 4 or 5, what the regulations will be. Do you think if we go back to level 4 or 5, the same regulations that was active during this past level 4 or 5 will be active again, or do you think that will change again?
Well, at this stage, if I look at the history and with all of the changes, I can't say. Hopefully, just to give some security to the children and stability, I hope they stay with the current regulations as they are, which, with the movement of the children. And if you have to get a permit, then so be it. At least you have that documentation. And with a court order or a parenting plan registered, then you'd be safe. So I think if they stick to those regulations, that'll help a lot.
Awesome. Belinda, also thanks, Neil and Michelle. I want to thank everybody that's joined us today. And Michelle, thanks for taking the time out. I know being a director at such a big law firm, you're obviously quite busy, and also trying to catch up all of the family law matters at the moment. I think the big thing is parents also always need to take the children into account and do what's best for the kids at the end.
Yes. No, any decision taken should be in the best interest of the minor children. It's of paramount importance. And as I said, that communication, the fact that it's broken down between the two parents shouldn't affect the children, and as well as the relationship with the other party. I mean, during this time, and it's the last thought I want to leave with, if the parents isn't able to see their children, I would encourage more communication between them. We've been given so many media options or media platforms like Zoom, like WhatsApp calls. So have that communication, visual communication, audio communication, to ensure that you hold and you rebuild that relationship with your child. I mean, that's of utmost importance during these times, to give them that security.
Awesome. I completely agree
Right.
with you. Michelle, thanks for joining us. I've given your email address out. I'm sure quite a few people that was a bit shy to talk about such a serious topic on air will email you with regards to that. So good luck. And what's your plans for lockdown free? Are you excited to go out? Any plans?
Well, at this stage, I think family is of importance. So, we'd like to socialize with our family, socialize with our friends. I think that's something we've taken for granted. So that'll be one of the first priorities we do.
Awesome. Well, thank you so much for joining us. And don't forget, everybody else, next week, Wednesday of eDefender, there'll be no In Conversation this coming Friday or next week, Monday. It'll be next Wednesday right here at 3 o'clock with eDefender Q&A. Michelle, thanks so much. And
Thanks, Neil.
for joining me.
Thanks for the opportunity. I'll speak to you soon.
Awesome.
Bye.
Thanks so much. Bye-bye. I'll see you next week, Wednesday. Any questions, please do email Michelle and she'll be able to get back to you in terms of that. I thank everybody that's joined us, and also through this whole series from the beginning of April, we've had great speakers on where we've really touched on nice topics specifically. So have a good week and good luck with month end as well from everybody.